Hello, I'm Rob Clementi, the Chief Executive of 10, the Education Network. In today's Law Bites, we're going to take a sneak peek at one of the key presentations at our upcoming Employment Law Conference on the Gold Coast. With me today is Elizabeth Devine, Principal at Devine Law at Work in Sydney. Elizabeth will be speaking on flexible work, one of the topics du jour following the COVID lockdowns. Elizabeth, thanks for joining us. Can you tell me more about the recent amendments to the Fair Work Act in relation to flexible work?
Thanks, Rob. I certainly can. Now, flexible working isn't anything new. Since the early 90s, we've had a big movement towards flexibility, particularly driven by employers. And in the early 2000s, we saw a bit of a balancing and correction in favour also of employees and the right to request flexible working arrangements. But whilst employers have had obligations to ensure that they dealt with those requests for flexible working arrangements properly, there's never been any ability for employees to enforce that right. That changed in June of 2023, so just a few weeks ago. So it's very recent changes to the Fair Work Act. And what they do is they introduce a much more onerous scheme of obligations for employers to ensure that they treat these requests for flexible working seriously. They genuinely endeavour to reach an agreement with the employee, which may not be exactly on the terms that the employee has requested, but certainly engaging in a proper discussion and consideration of each party's interests in the situation and wherever possible, accommodating that request. If the matter is not resolved under this new scheme, then what will happen is either party, employer or employee, can bring the matter before the Fair Work Commission, and it can be the subject of a dispute consideration by the Commission. Wherever possible, the Commission won't be arbitrating the matter, but if it ends up having to, then it can issue orders against employers. So if it finds that a refusal of a request hasn't been reasonable, then it can in fact order the employer to accept the request. And a failure by an employer can result in some fairly significant penalties. So these are really significant developments as part of an evolution in the way the law looks at flexible working over the last 30 years. So is it a non-negotiable right in the workplace now in 2023? Come along to the conference and find out.
Elizabeth, thank you very much. And to learn more and register for the conference, just go to our website, tved.net.au. In the meantime, thank you very much for listening.